Just as a bit of an introduction, my name's Bruce Baskerville. I'm an RAHS counsellor. I've been a member of Historical Society since I was 16, so that's a sort of tragic biography. And because of that, and I've been a member of the Society wherever I've lived, all over the place. So I've been through quite a lot of changes in constitutions and writing constitutions in the first place. And I'm a member of the RAHS's Constitutional Review Working Group because we're reviewing our own constitution at the moment as well. Now, I want to emphasise I'm not a lawyer, I'm a historian. And so I'm speaking about my experience. This is what has informed me, not law as such. The aims of the workshop today is firstly to reaffirm the importance of your constitution and why you have it, to outline recent changes in the Associations Incorporation Act and Regulation and the model constitution, and alert you to what you need to do to check and update your own constitution. So in a nutshell, that's the sort of territory we'll cover. The structure of the workshop is, we've got 8 slides here. So in 40 minutes, it's about 5 minutes on each one. Suzanne and I will both speak at different times. You can ask questions as we go along, but we'll also have 20 minutes at the end for questions, so if you don't get one in then, don't worry. And if you've got a sort of more complicated and detailed one, we'll have morning tea afterwards, so you're quite welcome to discuss with Suzanne or I, more detailed and specific questions. Just a brief history of association. Doing your handout there's a page and a bit written about that, so I won't read all of that. But just to touch upon a couple of points there. Associations as such are very old sorts of institutions and organisations, and there's a bit of a history there, but I think it's from the 1830s that they take the form that we would know them today, really. And in 1850, a historian in Britain wrote, "Ours is the age of societies. For the redress of every oppression that is done under the sun, there's a public meeting. For the cure of every sorrow, there are patrons, vice presidents and secretaries. For the diffusion of every blessing, there is a committee." So I'm sure that will all sound familiar to you. And some of the sort of more modern forms of associations that date from the 19th century, and some of these, of course, you'll be familiar with the names. The Society for the Abolition of Slavery, that was founded in 1823. Society for the Prevention of Cruelty to Animals, the next year in 1824. Geographical Society in 1830, the Aborigines Protection Society in 1837, Archaeological Institute in 1844, and of course the Historical Society in 1868. Now those are all English institutions, but you see the pattern there. In New South Wales and other colonial settings, their counterparts were formed. So for example, in New South Wales, the New South Wales Society for the Prevention of Cruelty to Animals was formed in 1873, and of course our Historical Society was formed in 1901. And if you look at the dates, there's about 30 years between when they form in Britain and when one forms in the colonies. And I think it's a generation is the change. And most of these associations also eventually received royal honorifics to sort of honour and as a patronage. Freedom of association is now considered as a basic human right in Western civil societies, but there's not much freedom in an association if it's run according to the whims or the fear of a single person or a small group of people. The rules of an association, your constitution, are to ensure that it's run in accordance with the law and that it works towards its objectives and that decisions are made collectively and not by a single person. So a really basic concept to understand here is the idea about the body corporate. That is, it's a group of individuals who voluntarily band together for a certain purpose. And in doing so, they form another legal body or a juristic person, as it's sometimes called, that's quite separate from each of the individuals that make it up. Now that legal body can act like a natural person. It can sue and it can be sued. That's usually the sort of threshold way of describing it. But in doing so, it protects the individual people from being sued or prosecuted because of the actions of the body. Associations first formed either as unincorporated associations under common law, and if you're really interested in that, it's quite fascinating to have a look at. The issue that tended to come out of them was when it wound up, there were all these disputes about who got the assets. So partly the introduction of incorporated associations legislation was a way to respond to that and to provide a more structured way of dealing with that rather than always going to court. Companies are much older than associations, but these gradually became a lot more complex and mainly directed to commercial purposes and so not really suitable for the sorts of things that we would want to do. They're not really suitable for small bodies with very little in the way of money and assets. So I've set out there, like the first of these acts was in South Australia in 1858. They come in different states and territories at different times, right up to 2005 when Norfolk Island was the last one to adopt such an act. It's important to just remember there, associations are managed under state or territory laws, companies under federal law. So there's a basic distinction there. So I just think we need to remember that legacy, which is set out there for you to read later. Running our associations properly for the benefit of the members and in pursuit of clear objectives is a way that we honour that heritage. As committee members and office bearers, we're stewards of that inheritance, and we need to work to ensure we pass it on in a better condition to our successors than in which we inherit it. A healthy civil society is made up of healthy associations. So what's in a constitution? Well, in one sense, it's the legal framework within which you operate. It's basic but fundamental set of rules. It's the roadmap by which you run your association. What is the constitution? Well, now, of course, you'll all be familiar with your own constitution. You've got it based on the model constitution, but there are two other parts to it that is really important to understand. You have the Act, and I just have bound up in this one, the regulation. Now, the regulation is what's just been changed quite a bit, and that's what we'll talk about more. But I want to make you aware that you have those three parts to it, because while your constitution proper is the bit you'll look at mostly, do most things with and so on, there are parts of it that are not written in your constitution but which are in the regulation or the Act. And again, we'll come back to it a bit later on about how you can make yourself aware of that and not accidentally misdoing something. But it can be confusing, but it's important to just keep that in mind. The constitution, it should state what you do. What are your objects? That's a really important part. And sometimes it's a part that's not given a lot of attention because people assume, well, we'll know what we're doing, so they don't really write down very clearly what it is that they're trying to do. If you find your society is doing things that aren't mentioned or implicit in your objects, then you need to ask, well, why are we doing this? What is our authority to be doing this? So, the RAHS in its constitution says our purpose, and its very first point, is the study of Australian history and the preservation of Australian heritage, I think, something like that. You can see it's quite general and quite broad, but it's also actually quite specific. And if we're doing something which isn't about those sorts of objectives, then we can ask ourselves, yes, Suzanne?
I was going to just make the point with objectives, because we've had a bit of a debate about this. With your objectives, keep it, as Bruce said, general, but don't actually state how you're going to do it. So we say that we want to promote Australian history. We don't list all the ways that we do that in our constitution, because we don't know how the world is going to change. So, for example, with social media coming on and new platforms, you don't want to write in your constitution, we want to promote the history of our area using Facebook and Twitter, and then all of a sudden something new comes in. So when you're doing your objective, as Bruce said, you want it to be specific. It might be about promoting a certain part of history or about your local area. But don't actually in your constitution write exactly how you're going to do that, because it might change, depending on how technology changes or whether you decide to do publications or run events.
Yes, and look, the RAHS one is a good model to look at. Since 1901, that bit I just said has always been in the Constitution. But over the years, more things have been added and taken out and subtracted and put in. And at times, I think at one point it had like 20 different objectives. And they became more and more tiny and finely focused. But it actually meant that caused other problems. So general, but nevertheless specific enough for what you want to do. Your constitution should also authorise the actions and activities of your office bearers and members. So it says the committee will do X, or the president will do such and such. That's their authority for doing that. And again, if the committee or one of your office bearers is doing something which it appears from the constitution they're not meant to be doing, that's where you go and look to see whether they should or should not be doing it. Your constitution, it's not a top secret document. And I do want to emphasise that because I know it is in some societies. It should be freely available to your members. You can have it on your website. That's the way I suggest you do it. Then if someone wants to look at it, they can easily find it. And you can give new members a copy when they join and so on. But it shouldn't be the case, and I've been in organisations where it is, where you say, where's the constitution, and nobody actually knows where it is, or what's in it, or who's got it. So try not to let yourself get to that point. And if you have, find the damn thing. And the more people know it, the less likely you are to run into trouble. It might seem counterintuitive, but I think that's true. And my last point there is on your membership application or renewal forms, you can include a phrase that you will see on some, that the member or the person commits to abiding by the Constitution and the rules of the association. Now that's to make them aware that such things exist, but also it is a commitment. You know, that's someone saying, yes, I will abide by the rules, which can be an important psychological point. So what needs to be in your Constitution? Well, there are some legal requirements. Now, name and objects. Now, this is one thing I find quite annoying about the Model Constitution. In the last time it was revised, not this time, but the last time, those were taken out of the Model Constitution and you register them separately with fair trading. But I actually find it quite irritating because if you're only looking at your Constitution, well, the first thing you find is it doesn't have your name in it, it doesn't have your objects, because they're somewhere else. However, that does not mean you can't do that. So in an example that I'll refer to a couple of times, which is the Professional Historians Association Constitution that was reviewed a couple of years ago, we put the name and the objects into the Constitution. So, you know, the Constitution starts Clause 1, which is usually the definitions, and on it goes. So we put them before that, and we called them Clause A and Clause B. So it didn't affect the numbering or anything else. It depends how you work, but typically, as I said before, people will just look at that one document, the Constitution, and assume everything is in it. So if yours doesn't have your name and your objects in it, you may consider putting them in it. There's not a problem doing it. There are now new requirements that came in through the amendments in 2016, which were really to the regulation rather than the Act. Some of these things you may already be doing anyway. Some of these changes were refinements rather than new things. The first one is about the fiduciary duty of committee members. You understand the concept of fiduciary duty. When you're sitting in a meeting, you are sitting there as a member of that committee or council or group. You're not sitting there as an individual person. So your fiduciary duty is that you're acting in the best interests of the association when you're sitting in the meeting. The change is now really stressed that committee members need to exercise due care and diligence and act in good faith. They have to act in the interests of the association and not their personal interests. Now, having personal, we all have them, so that's not the problem as such, right? And the regulation again does provide for declaring interests, and that's what you should do. So when we have an RAX council meeting, the first order of business is declaration of interests. And so if you see anything on the agenda which you have a personal interest in, you declare it at that point. Now that doesn't mean you can't take part in the discussion and so on, but it means it's everybody else at the meeting knows you have a personal interest in that as well as your fiduciary interest as a member of the committee. So it's about transparency and about being honest, really. I mean, my personal thing is if you declare an interest, I prefer if that comes up for discussion than to leave the room or something. Then there's no question about whether you've tried to influence things and so on. But the requirements in the regulation are quite clear on this, and you need to take them quite seriously and make sure our committee members all understand this. Now, electronic voting is permitted. It was permitted in the previous version, but there's a stronger emphasis on it this time. And this is partly as an offset to discouraging the use of proxy votes. The Model Constitution has a blanket, pretty bold clause saying there will be no proxy votes. So if you want proxy votes, you have to change that to say that there are. But the reason, as my understanding is, the reason for removing proxy votes is, one, it's too open to abuse and people gathering and up and coming with 60 proxy votes to the AGM where there's only 3 people. And I'm sure that would never happen, but we read in the papers that it does. The other thing is, as I said, technology now allows for other ways for people who are not physically present to still be at a meeting. So an example might be Skype. So you might have a committee meeting and you might have a person who's attending the meeting on a laptop by Skype. The regulation doesn't say Skype or internet or anything, it just says technology, and it defines the technology as being anything that allows both the person who's physically somewhere else and the committee members to hear and understand each other. So it might be Skype, it might be a conference call on a phone, it could be those sorts of things. But if you want to keep proxy voting, you need to actually say you want to do that. Electronic voting, however, is the preferred method from fair trading, and it's also in the corporations law about companies. So, I mean, that's the trend, and I think that you're better to try to come to terms with that and work out. Look, what it says in the regulation, I think it's the regulation, is as long as you can all hear each other and so on, and so that means that person is counted in your quorum at being at the meeting, and when they vote, like if it's a committee meeting, you're probably just voting by voice. It does actually provide some more, in the regulations, some more complicated arrangements there about doing postal votes and conducting ballots, if you really need to get to that.
Yes, I was just wondering, in an annual general meeting where there might be 40 people present, using Skype, and 4 people trying to use Skype.
Well, I think that, look, that is possible. You know, I don't think we should think that's not possible. It's unlikely, but it's possible. Again, it's going to be that, provided you've got the technology that enables everybody who's on Skype to be able to see and hear what everyone else who's Skyping as well, you know, it would be probably acceptable. You know, companies and so on are much more used to doing this, but in our sector, we probably need to catch up with doing that sort of thing. I suggest you do a few experiments with trying with Skype meetings. If you're having the meeting and some people are participating by email, which seems to be quite tricky, but you could do it, that would be acceptable. So that's what they're really trying to get you to do. If you're on the committee or a member, it's your responsibility to actually participate rather than try and get someone else to do it for you. I mean, that's the general principle, I think, there. If the person or the people who are participating electronically, it's clearly everybody else can see and hear them, then they're counted as being in your quorum. So then, therefore, their vote counts as the same as anybody else's. And I would think conference calls on just with a phone on the table, or Skyping is good ways to sort of do some experimenting and see if it works for you, and what doesn't, and how you might be able to make it work better. The model constitution now has a provision that allows you to do it, right? It doesn't say you have to. So if you're going to keep proxies, you might not want to keep the electronic. Accounts and records, so all sorts of records, minutes and so on, and financial records, can all be kept electronically. The regulation specifies for 5 years as a minimum period. It also, interestingly, has a clause that they have to be convertible to hard copy. So if someone says, I want a printout of the minutes of the last meeting, you have to be able to provide that to them. Now, I presume that's because it's on an assumption not everybody will have internet access or something, okay? But it does say they need to be convertible to a hard copy. So I'm not quite sure what an electronic copy you would keep. You couldn't actually print out, but presumably there is some. Judith?
I would say as historical societies, you'd want to be able to keep your records for far longer because it's your history. So I know at Parramatta, we have the 1913 records in hard copy, and they're a wonderful source of history of our society. So you don't want to be all modern and only keep things for 5 years.
No, I think the 5 year, look, it wasn't in there before.
That's a legal issue.
And I think it's been put in there as a minimum time you have to keep them.
Yeah.
Because I think there's perhaps been, and probably not with historical societies, instances of records being disposed of very quickly. And so this is saying, look, you do actually need to keep them for 5 years, so which is like minutes and so on. I just assume there wasn't some flaw there. Look, it's interesting, there are something like 35,000 associations in New South Wales. So you can imagine, while ours are all probably very good, there may be some other sectors where they need to deal with these things. Maximum term limits for office bearers. Now, look, it says in the model, it's expressed in the opposite way. It says there are no consecutive term limits, but the idea is you're meant to actually say that there are some. So an office bearer can serve 2 consecutive terms, or 3, or whatever your limit is. It didn't have a limit in there before, so now it's put in there specifically to make you think, oh, should we have those limits? And again, look, my experience really would be you should. That could be for 5 consecutive terms, that's 5 years. Look, I'm sure you're all aware of the problem somewhere or other where one person's been president for 23 years and it's become their fiefdom, and they themselves come to believe that if they're not there, the society will fall apart. So this is a way to help ease people out of these positions without it seeming like it's about them. But also, I think it also keeps your society healthier because it means you've got a bit of turnover there all the time. If the term limit's there, you're able to say, look, the term, next year my term limit expires. I won't be able to do it again. And sometimes that forces the talent to rise up, so to speak. No, well, look, it does say consecutive terms. So remember, that means a person. Say if you had a limit of five consecutive terms, a person could do 5 years. They may then become, treasurer for a year, and then they could start their consecutive 5 years again as president if you want to do that. But just again, my observation is once you do something like that and the person does move to another position, generally the sky doesn't fall in, and people realise, oh, it can work. And so you don't need to go back to that. But you could do that. It also means someone else gets a turn to see what that's like in that other job, another position, and they think, oh, actually, I can do this. Or people might say, oh, he's quite good at that,
Bruce, I know of a society that elected their president for life in the minutes,
Yes.
and he got Alzheimer's.
Yeah. Oh. Well, there's a
They had to
problem
close
with
the
that.
society down and reopen with a new president to get around that issue.
Look, I think that having the term limits can save you from all sorts of unforeseen problems, of which that's an outstanding example. I mean, but electing someone for life, I certainly wouldn't want to do that.
I know.
But you understand how it happens though sometimes, because that person can seem like a giant in the association, and that it'll be good, it's safe in their hands, they've been there forever, but that is a trap. That must include the winding up clause. Now, the winding up clause has always been in the model, generally to the effect of saying, look, if you wind up, you have to give your assets and so on to another association with similar objectives, right? So what's happened here, that's still there, but it now has an additional clause that the Director General has to be satisfied there's no liabilities still from the association winding up. So you can't wind up because you've got $100,000 worth of debt and, oh, we're out of here. So it's actually very useful to have that clause. Suzanne, you want to say something?
Yeah, I just wanted to say about winding up clauses. I think it's really important, this not in your constitution, but operationally, that once a year you check who has authorisations on your bank accounts. Because the RHS itself has run into trouble. We were having some banking issues, and then I realised that there was people on our bank accounts who, had passed away. So, and you can't wind, and it's happened to historical societies where they don't realise the names. They try to wind up, but the names on the bank accounts are really out of date. So what we've done now is every year we have an election and a new committee, and it's a standing agenda item that once a year we review who are the people who are authorised on our bank accounts, and we change them because it's a really easy thing to forget. And then you run into trouble if someone resigns or you need to wind up and you don't have the permissions to do what you need to do. So I would make that anytime you elect a new president, a new committee, that you call into your bank and you double check who's all the authorisations.
And look, and I'm sure if you change signatures at the bank when you've had a change of office periods, you know how tedious and difficult that can be, right? So yes, don't let it go too long, because especially if one of them dies, you're going to have even more trouble with it. Your financial year should be 1st of July to the 30th of June. Now look, that's probably what most people have, but there are some odd arrangements and so on. So this is trying to get everyone. Again, it still allows you, if you want to have a different type of financial year, you can, but the regulation is directing really to say, look, unless you've got some really particular reason, you should be using this standard financial year. It gets related to your reporting to other people, what you do and so on. Your official.
Ours is not.
No, you don't have to change it, right? But at some point, I think you probably will. So you either do it under your own steam, or at some point in the future there'll be some other change.
So what do you do a 6-month thing?
Look, it has a transition provision as well, to say if you're changing, here's a transition one to get you from where you are to the 1st of July to 30th of June year. So it won't fall in a hole. Yeah.
And that would mean you'd have to have the election off spares at a different time, wouldn't it?
Well, you might do. It depends how you have them set up and when you have your AGM. Yeah. Official address. Look, it's not actually in your model constitution and so on, but it is when you go to fair trading. They want an official address for you. It does say it needs to be your premises. So if you have a museum or library or somewhere which is your place, what it is, the address has to be a physical place, not like a post box number. So if there's some reason that fair trading need to find you, there's a place they can go to. So for examples they had of bad ones were like sporting clubs that used an oval as their address. so where they weren't there, or the post box was another typical one. So it either needs to be either a premises or your public officer's address.
Is that put in the Constitution?
No, it's not in there, but it was in the discussion paper that went with it. And so, like I said, when you go to Fair Trading to do your updates or changes, they want an official address. So a post box won't do it anymore. Now, the deemed to apply issue, this is really bad if you use a model constitution. You know, like it has been revised a number of times in recent years, the model. And apparently this has caused some problems for some people in not knowing which version they've kept up with, or they're using the old one and so on. Now, the deemed to apply means it now refers to the model constitution as enforced from time to time. So that means whenever the model's revised, it's assumed that those revisions are now enforced in your constitution, even if you haven't actually changed it. There's potential there for confusion, I think, and partly, I'll come back to it in a little while, I think you need to make sure you regularly are updating your constitution and dealing with problematic issues. And I'd suggest every 5 years, and I'll say why soon enough. And the other thing is, it's useful to have a general power for your committee to make bylaws or guidelines or so on. It's implied in the model constitution, which says the committee can pretty much do anything. But it does help you to manage your operational issues, make sure they're under the authority of the Constitution without them actually being in the Constitution. One of the complaints that was made during the review of the Act from very small associations was that the cost of submitting paperwork for which there were fees was sometimes more than the cost than what they brought in income in a year. Now I'm talking about associations that had an income of like $86 was one of them. So, you know, there were Tier 1 and Tier 2 associations. So the fees for the Tier 1, that's the richer ones, isn't it, went up, and the trade-off was the Tier 2 associations, which is pretty much all of us, went down. So there should be cheaper fees. They're not that much cheaper, but they are cheaper. So yeah, that's just, if you lodge a change in your constitution, you've got to pay a fee. So what does not need to be in it? Well, operational matters. Now, look, Suzanne's going to talk a little bit more about this. So, like financial management, your banking authorisations she mentioned before there, fees and charges, day-to-day housekeeping things like operating hours for your museum or library, rosters, key schedules, things like that, like they're day-to-day operational things. They're not about what your bigger picture, how you operate your whole society. So they should not be in your constitution. You know, I said before, if your committee can, you know, issue some guidelines or bylaws or rules to deal with those things, but they shouldn't actually be in there. Now, I have seen them in there. I've seen museum operating hours in the constitution. That's not the place to do it, because just think when you want to change them. And finally, they're delegating all power to a single office bearer. A constitution of which I'm well aware actually has a clause in it that says when the committee's not in meeting, the president exercises all power. Now, I'm sure you can see a flaw in that straight away. The whole thrust of the association's incorporation law and everything else is that the committee manages the society, your association. That's why you have several office bearers. That's why you elect a few people. It's about collective or collegial decision making. It's a basic principle in the whole idea of an association, that it's not about one person. And go back again to the idea of the fiduciary duty and responsibility. In making sure your association is managed properly, you have to pay your part. Don't have clauses that delegate all authority to the president or to anybody else. Now, Suzanne, did you just want to talk about this one?
I just want to quickly talk about operational matters, because a lot of people try and solve all their problems in their constitution. But as Bruce said, you think of your constitution as your foundational document, and then you have like day-to-day procedures in place to, you know, manage your day-to-day business. Now, I know in the law we have the concept, as Bruce mentioned, of Tier 1 and Tier 2 organisations. So most historical societies would be Tier 2, which means that you earn less than $250,000, or you have less than $500,000 a year in current assets. So by current assets, they mean money in your bank account. But if, say, you're doing a major fundraising thing to buy a property, you might end up having $500,000 in your bank account. So, for example, our society, the Royal, we've been doing big fundraising for our building. Once you start hitting the $500,000 mark, it then means your accounts have to be professionally audited. You have to have an auditor. You have to submit audit accounts to all your members. Most of you won't fall in that bracket. So what you have to do is you have to make sure that you keep really good financial records. And there is no point in saying that you have a treasurer and the treasurer looks after the money, because first of all, lots of historical societies get themselves into dreadful trouble with that attitude, especially around conflict of interest. The treasurer might be making decisions and using vendors or paying for things and always picking members of their family to do work. And you as a committee, by you allowing that to happen, you're all held equally responsible. So I would say it's really, really important. You don't have to have it in your constitution, but that every time your committee meets, everyone has a look at the financial records. And Bruce confessed to being members of a historical society since he was 16. I used to be an accountant and worked for Macquarie Bank in a previous life. So I would say that financial records, you know that they're being well kept when they're really easy to understand. And you know something is dodgy is going on when you look at the financial records, and as a non-accountant, you don't understand what's going on. So as a committee member, everyone should see a list with numbers and written in plain English of this is where we earned our money this month, this is where we spent the money this month. And you as a committee member, if you're worried about something and it doesn't look right, you ask the questions. Because if something dodgy, for want of a better word, has gone on, you're all responsible, not just the treasurer. So I just want to really stress that point. The New South Wales Office of Sporting Associations, they've got really, really good guidelines on how to manage your money, from how to manage your petty cash, to how to manage your purchase of assets, and they're really, really well written. So there's about 4 pages of that in the handout that you can just take away. And we might actually do a separate session on financial management if anyone in the audience thinks that's worthwhile. And the second thing I want to talk about quickly is there anyone here who's a registered charity, like are your historical societies registered charities? If you're a registered charity, they're very strict about keeping good financial records. And about once a month, 12 charities get struck off the charity registers. And it's primarily because of conflict of interest around finances, about people privately benefiting from the charity, or by not keeping good financial records. Now, this second list is really, really good because it doesn't talk about just keeping financial records. It also talks about all the different kinds of documents that you should be keeping in order to run your organization. So as Judith mentioned about keeping copies of your minutes because they're historical records, this discusses having the documents about what your charitable purpose or what your organizational purpose is, so that your committee is always focused on it. It lists other sort of useful documents as well, you know, around communicating and setting up your committees and how you manage them. So that's another document for you to take away. I would say that the majority of calls that we get, because historical societies are running into issues, I'd say the number one is what Bruce has mentioned before, where one person kind of forgets that it is an association and it's about a group of people working together, and it's not a dictatorship. I would say that would be the number one sort of issue that people run into. I'd say the second issue that people run into is around conflict of interest and money, to be honest, where someone decides that they want to decorate their museum and they use the Historical Society's money to buy pictures that their daughter drew to hang up in the museum. Like, that's a serious, serious conflict of interest. I would say that would be the second thing. However, I don't want to spread doom and gloom. I mean, we have 380 historical societies, and we probably only get a call like that once every 3 or 4 months. Most people do the right thing, and you're all there because you have something that you feel really, really passionate about. However, what your constitution and these governing documents do, if unfortunately you attract a bad apple, that it provides your organisation with some protection.
The other question I was looking at was that I just skimmed through that.
Yeah.
One of the, if you were in tier 2, you don't have to have your records audited.
Yes, and you shouldn't, because an auditor is quite expensive. You know, an auditor can cost, you know, between $2,000 and $10,000. So you really want to be having, like, you know, you really want to be handling major donations. But you can actually put in your constitution that you want your accounts audited. So say you're a tier 2, you can make a decision. Maybe you've run into financial problems before, that every year you want audited accounts presented to your committee. You can put that clause in your constitution as a tier 2.
You might be interested to know there's now these social work groups who are offering charities and not-for-profits to do auditing.
Oh, great. I would actually say if you didn't have to pay for it, I think it's worth doing.
They might only charge
Yeah.
minimal as
Yeah.
opposed to a professional accountant. There's one called Three Bridges in our
great.
district, but they're, you know,
Really, because what auditors do is they don't just look at your accounts, they'll often make recommendations on how to improve your financial processes. I would say don't have it in your constitution that you have to get your accounts audited, like if you don't have to. But if you have the opportunity to have an auditor to come in and check how you're keeping your records and present the financial accounts, then I think it's worth doing. But look at the cost benefit, and if you can get them for, you know, $400 or $500 and you can afford it, or even better, get it for free. Normally, if you have a committee member who is an accountant, you can't audit your own accounts. It needs to be an outsider auditing it, but if you can get access to that service, I think that's wonderful. It's not an audit unless it's actually, you know, it's done by the Australian accounting standards, and those, in order to actually do an audit, you actually have to be registered as an auditor. You can't, I mean, you can do what's called your own internal audit, where you actually, maybe you might have someone who's a friend but not connected to society who can go and review things and give you some ideas of how to improve your financial records. But in order for it to be a proper audited accounts, it has to be a registered audit, and they have to actually prepare their accounts according to, like, the Australian accounting standards. It's pretty much a template. So.
And just on the point that you were saying there, look, I was in an association, and we put in a provision to require audits, but that was because there'd been a period of a treasurer who, shall we say, didn't really undertake their duties at all. And we needed some outside person to be able to actually say that. In that case, that worked well. But it wasn't getting a professional audit, it was really just getting someone who wasn't in the association to look at it. So look, just amending how to do it. This is my suggestion, right? Just form a small working group that's responsible to your committee. You know, might only be 2 or 3 people, but people who have got some knowledge about or some passion for this and want to do it. A smaller group will get things done better, is my experience. The bigger your group is to begin with, the more talk but the less action, if you know what I mean. Look, I use the model constitution. You can get it in a Word document, and you can then use track changes to see what you're doing. It's a very good way to be showing other people what are the changes that are being proposed, so that they can understand what's going on and also have confidence that you're not just rewriting the whole thing the way you like it and getting rid of all the bits they like. And I'll show you an example on the next slide. Engage your members in the process, publish on your website or in your newsletter, make it a regular topic to report to the committee meetings and so on. Like, get people involved and know that you're doing it. Your final amendments will have to go to a special general meeting to be approved. There should not be any surprises by the time you get to that point. This is why I'm saying engage your members earlier. The more that they know that you're reviewing the Constitution, the less problem you're going to have later on down the track. I can't emphasise that enough, because you don't want to get to your special general meeting and then a whole lot of argy-bargy blows up. It all becomes controversial because all these people didn't know what was going on and ask a whole lot of questions which the person being asked may not be able to effectively respond to. It may look like you're trying to hide something. It's better to resolve, flush out the issues and resolve them long before you get to the special general meeting. By the time you get there, everyone should be really on board and be saying, this is a great thing, It should go through your special general meeting fairly easily, and it should be a cause for celebration. You know, if it gets there and there's a whole lot of argument and nastiness and it all breaks up with bad feeling, then the job hasn't been done properly, and it's the very thing you want to avoid at all costs, really. Once it's been through your special general meeting, you then have to register that with the changes with fair trading. As I said, the recent changes have reduced the fees for doing that. Don't delay or forget to do it. There are time limits on which you need to do it in, so you need to be, I can't remember what they're off the top of my head, but something like 6 weeks, which you need to take it to them. If you don't do that, then all that work you did goes down the drain, because you've got to go all the way back to the beginning and do it all over again. If you don't already use the model constitution, then ideally I'd encourage you to change to doing that. It's quite flexible for the things you can change in it, just as I've said with some of those things before, like with the term limits. There are no consecutive term limits. The point of that being there is to make you put some in. You know, many of the complex issues are already resolved for you in that model. So you don't have to continually sort of reinvent the wheel, and it's fairly standard across Australia. You know, New South Wales had those amendments last year. Well, WA, Victoria, Tasmania also had changes in their acts in that year. And if you sort of keep an eye on them, you see they're constantly always changing. But one of the things that's coming from that is they're becoming more and more similar. So if you know how it operates in New South Wales, you're pretty sure you know how it operates everywhere else, and vice versa. The Act itself requires that the Act has a review every 5 years. So I think you need to get used to periodically amending your constitution. And that's why the 5-year thing I think is good. You wait, see what the, you know, what is it, 2016, so that means the next one's about 2021, something like that. Make it part of your committee's culture. Look, oh, there's something we should think about changing that. And then you might even think to have a committee member you nominate as your constitution officer or something, whose job it is to keep up with what's going on and keep responsible for it. You know, there was a time when you had a constitution and you never looked at it, never changed it for 30 years. That's no longer the case. Well, it shouldn't be the case. And the changes, as I said, those deemed to apply things and so on can catch you out if you're not on top of it. So I recommend you use the model one and adjust it to your circumstances, because the really basic core stuff in there, like about disciplinary measures for members, about fiduciary responsibilities of committee members, they've already been resolved and worked out through all sorts of court cases and things. You don't need to go and reinvent all of that all over again. Like, they're the tricky things and they're already there. So you can focus more on, you know, what are your objectives? Have you got that right? You know, have you got your name right? And so on. I just really encourage you to do that. The Act is reviewed every 5 years, so I think the regulation's going to have some sort of changes probably every 5 years, which is going to impact upon your own constitution. So this is just an example, like using the track changes of one. So obviously, you know, if you've seen track changes, that's what it looks like. There's the new bit you're putting in, here's the old bits you've taken out. Everyone can see it, so you can show the committee, look, this is the sort of thing you asked for, this is what it looks like, are you happy with that? And typically, not everyone will be. So, oh, I don't like that word, or what, but that's all right, because then you're dealing with it in that context and that level, not at the SGM, where that's the last thing you want to be happening. See, this little bit here, it says note, and so it's about the duties of the secretary. Now the note says, under the Act, the secretary is required to maintain a register of committee members that's available to members for inspection. The regulation prescribes the details that have to be recorded in the register. So none of those things are actually in your model constitution, but here is a requirement in the Act and another bit in the regulation about what you need to do. So when we change this one, we actually put quite a lot of these notes in them. Now it'll generally say right in the front of your constitution, if you're using the model one, that the notes are not actually part of the constitution, that's fine, like you actually don't want them to be. But they're like little advisory things. So here's your secretary, you know, they've just been elected to the position, they're looking at what they have to do. So this alerts them, look, you have to do this and this is the way you need to do it, it's here. So that's where you can get tripped up sometimes, where you think you're doing the right thing because you haven't realised there's something in the Act or the regulation. But look, that's just as a technique. I find the track changes a useful thing to do. There's one that had track changes, went to the committee, we had to put more changes in, so that's what the green writing is. And they had another lot of changes. But it's better to sort them out that way. Don't have that happen at your special general meeting. Yeah, well look, so this one, when we're doing that, we had a working group who did it, and then at each committee meeting, we'd report back to them and say, look, this is what we've done. what's your feedback on that? As each time you did that, there was less and less things there was feedback on. Look, we're at the special general meeting. We did have 2 copies, right? One was the clean copy, which is just the final version the committee is recommending, and one was the copy with all those changes in it. Now, and so that was about transparency and say, look, there you can see what's been changed and what hasn't been. And well, luckily in that instance, there were no tricky questions. But I know there will be wordsmiths and bush lawyers who will want to say something. And it's better to see them long before the special general meeting. I'm going to say, look, the working group, we know you've got an interest in this, Bob, would you like to come and have a talk about it? Like something like that. But, you know, it's quite valid what they want to say, but sometimes people just have a way of saying things that take up a lot of time, and so it's more useful to be able to do it like this. You'd have like your special general meeting, close it, and then reopen as your thing. But yes, but you have to have its own standalone meeting, yeah. It's not so much that it's the meeting, it's that you have to pass a special resolution to adopt the changes, and typically I think that's about 3/4 of the members present at the meeting or something. So, you know, you want to advertise it enough to make sure you've got the people and meet your quorum and don't fall over at that. But yeah, but it's a separate meeting, but they can be one straight after the other. So with this one, for example, you see, so you put name and objects in, so you see A and B, put them in, and there's here where the rest of it started. So we had 3 motions. One was to adopt the change of name, one was to adopt the changed objectives, and then one was to adopt the changes to the Constitution as attached. Because you register each of these bits separately, so and they each had to have their own special resolution. And with that, when we got onto these, well, actually all of them, it had all been distributed like I think a fortnight before the meeting, and already said when we sent them out, if you've got questions, let me know before the meeting, we might be able to deal with it. So I had a few like that. When we're at the meeting, I was able to talk through each of the changes and say, this is what it was, this is what we're going to do, these are the words that should achieve that. And it was pretty straightforward, even though there was quite a lot of changes. So look, we're coming nearly at the end. Not incorporated. So look, finally, if your association is not incorporated, which probably doesn't apply to any of you, but you may know of something like this, you will still have to have a set of rules. The regularity and complexity of the Act and the regulation, which I just pointed out before, you might think, oh, it's all too much, look. We're not going to worry about that. We just want to save the history of our area and get together for a cup of tea every month, That seems reasonable to do that, right? But the thing is, an unincorporated association, you will not be protected from being personally sued or prosecuted for any actions of that association. You will be personally responsible. So if you have a walking tour, say, and someone falls over on the tour and hurts themselves, it won't be the association they sue because it doesn't exist. It will be you and each one of you, right? That's the really big headline warning there. But you probably won't be able to operate a bank account. You will probably not be able to obtain insurance. You will not be able to take any action yourself against the association. So if one of the members says, she's been stealing someone's work, you can't do anything about it except personally sue that person because there's no association. It'll probably be difficult to get new members to sign up because they will be more and more aware of these sorts of disadvantages. And it'll be increasingly difficult to be eligible for grant programs. Most grant programs now want you to be an incorporated association. Yeah. Because essentially an unincorporated organisation has no legal existence. It's not a juristic person, that we said at the beginning. And that can be dangerous in today's litigious and regulated world. If you act or make any transaction in the name of the association, you remain personally responsible and liable for that. So that's not a situation you want to find yourself in. And it's not in the spirit of the association's incorporation, which is about working collectively and being responsible together. So really, just to conclude, just back to the beginning, we need to value our rich legacy of associations. They're a crucial element in a free and civil society. Running our associations properly for the benefit of our members and in pursuit of a clear objectives is a way that we honour that heritage. As committee members and office bearers, we're stewards of that inheritance, and we always need to be working to pass it on in better condition than we inherited it. A good committee member is a good steward, and that's where we are. We've got time for some questions now, and we'll also have some morning tea, which you can ask some other questions after that as well. So is there any sort of formal questions you want to ask from the floor?
We have multiple office bearers' titles, as distinct from just president, secretary, and then a committee. We have journal editor and museum
Okay,
officer and all this specifically in our election. Are we better off just making them committee and then giving them that responsibility when we first meet?
Look, my personal view is that's a better way. In that one I was showing before, that constitution there, what we did, we put in that, we said there's the office bearers, you know, your 4 standard ones, but then any committee member can be appointed to a portfolio. And so that's pretty much all it says, and it says portfolio holder has to report regularly back to the committee or something like that. But then the committee determines, we'll appoint you to the portfolio of journal editor. So it was a tidier way to do it, and it also allowed, look, your journal might close, but you've got a need for another person. So that was a sort of a more flexible
This
way.
has happened over the years.
Yeah, they accumulate.
We ended up
Yeah.
making up a name of special projects officer, which covered multiple things, but it would be better if we could be more specific for
I think-
portfolios.
I just think, say, committee members can be appointed to a portfolio. It's something as simple as that, right? And then the committee says what portfolio is they're appointed to. You can appoint just a member of the society to a portfolio, and if requested or if they want to, they can come to the committee meeting, report upon their portfolio, and then leave or sit in the gallery or whatever. Yeah. Okay, well we might formally close that. Thank you, everyone.
Thank you.